Aha, Georgievski, ja, ker ni danes, ni to.
Unfortunately for you, I will take the floor a little bit more from here. Well, I feel privileged in a way to be here at this marvelous conference, and that privilege is twofold. First, as you can notice, you've noticed from this particular moment, I'm a latecomer at this conference. It was just 5 days ago that we made the arrangements of participation here. But I'm very glad for that. I'm very grateful to the organizers, especially to Professor Rios, who made available for me that participation here. Second privilege, well, that is a privilege at all. I'm not a civil procedure lawyer. I'm a public international lawyer. Somebody yesterday mentioned that we're not lawyers at all, because public international law is not law proper. But here at this very particular conference, it gives me the privilege of not going into details into various arrangements and nuances underlying the whole system and the policies in this area. So I will just briefly turn to the broader context, to the question of the importance of the quality of national judiciaries for the implementation of those arrangements and for providing an effective access to civil justice for citizens. Well, that issue came out yesterday, I would say very vividly, at the discussions that were going on at the end of the morning session. There were some participants here that expressed even great pessimism about the prosperity of the whole project of providing a functional European Judicial Area, because of the disparities and differences in the quality of the judicial systems and of the judiciary within different countries. There were, I believe that was Mr. Gomez yesterday mentioned very accurately the division existent and the differences existent, especially between the southern countries' judicial systems, including the one in Spain, Portugal, Italy, and the northern ones. And he was quite pessimistic in that respect. Well, that is really important. I come from a country which is not a member state of the Union itself, but it's a candidate state for accession to the EU, but it's a very southern country. It's a southern country par excellence, I would say. It's much southern than Croatia, but it's a little bit above neighboring, who else? Greece. So we are on the south. And because we are in that part of the European area, that makes the Republic of Macedonia case very pertinent to explain how the deficiencies which exist in pertaining to the quality of the judiciary could reflect could produce deterrent effects to the overall implementation of the European Judicial Area project. Well, the importance of the judiciary and the quality of the judiciary in that respect have been recognized by European institutions as well in many documents that have been very accurately described and pointed at. For example, the 2006 European Commission's communication has underlined that the quality of the judiciary and the need to train properly the judges is a vital issue of the whole European Judicial Area project. In its 2008 resolution, for example, the Council itself have pointed the need to establish a common European judicial culture. So the link is there, and the link is there not accidentally. It has to deal very much with the fundamentals upon which this policy area lies upon. This policy area, the policies here, the arrangements that are present here also, are much decentralized. They are decentralized. They rely on only minimal standards that are set at the European level and on the principle of mutual recognition of judicial systems within member states. And because that is so, it is the judiciaries and it is the judges, after all, at the end, who are those who apply the arrangements and who are those that are responsible for ensuring effective access to civil justice, including what has become very much important these days, including ensuring for fundamental citizens' rights. Now, I see that the time is running, so I wouldn't talk about the changes that have been introduced in our legal system at the legislative level, changes pertaining to the reform of the judiciary, to increasing the level of accountability of the judges, including amendments that were introduced in a whole package of laws, legislation here that pertain, that have to ensure greater efficiencies of the judicial process. I will skip that. I will just mention that mere changes in legislation is simply not enough. Right? We are all aware of that. And I fully concur with Professor Zelat's yesterday's presentation, who was here, about the Croatian experience. Our experience is the same. Laws are easily passed. They're easily passed, very much without any proper deliberative process underlying them, in a very technical manner. And a lot of laws have been passed in that respect. Many of those putting quite a lot of strain and pressure on the judiciary, which is found somewhere in the middle. On the one hand, it is pressured too much, for the moment, very much, from the laws that have been adopted. On the other hand, they're really not in a shape to respond to those changes and to those requirements that are imposed at the legislative level on them. So I will skip that part of legislation. I will just tell you some our experiences, where our judiciary stands in terms of quality, what is the mental state that judges are now, at this moment, especially regarding their readiness to apply international and European law, which is a vital issue, I repeat, for establishing a common European judicial culture. I will just give you some brief data from a project. That's a pilot project that we have performed in our country, an inquiry of a total of some 50 judges on their readiness, their knowledgeability, their skillfulness at the moment, and their preparedness, which is very important, preparedness to apply international and European law. And the figures there, the data, is really, really discouraging. I will just give you some data on that. Well, so these are only 50 judges that have been inquired, but we're now expanding the number of judges. But my personal belief is that the figures that I will present to you will be only proved when 500 judges will be inquired in that respect. So what are the figures? Where do the mindset of our judges in Macedonia stand at the moment regarding applying international and especially European law? Well, on one question, one issue, some 73% of the inquired judges have been faced with cases where some international rule have been invoked by the parties in those cases. But only 7% of them have actually considered that rule in their final judgments. 7%, whereas some 20% have just invoked, called upon that rule or some other rule normally contained in an international agreement. We're not talking about the general international law, merely in their judgments, merely to strengthen their own finding and their own interpretation of the national law that they apply. Another figure, 20% of the judges inquired and do not think that international agreements ratified in Macedonia can be applied directly in our system. They think that they have to wait for a law, implementing legislation to be passed. This is really something we're telling them. Why? Because we have a monistic solution in our constitution. They simply disregard that solution. Well, even worse, speaking about the same story, our stabilization and association agreement with the European Union, well, 48% of the judges that were inquired also think that that agreement is not directly applicable, although it's a ratified agreement in our system. Some other figures, 55%, now speaking specifically for international and for European law, 55% of the judges, they say they wouldn't be able to follow the European Court of Justice jurisprudence because of the language barrier, something which is really a deterrent in that respect. Whereas on the other hand, 96% express a need, that they need further training and further training, despite the fact that training sessions have been organized in Macedonia for the last 10 years, and especially as of 2006, when the Academy for Judges and Public Prosecutors was established. Well, that academy offers quite a lot of programs for judges. Judges under legislation were also made, it is compulsory for them to attend courses, like probably here in Croatia as well. They have to accumulate a certain amount of credits, and the academy offers for the current judges continuous training. Well, they do come to the sessions, but the experience with the sessions is rather discouraging again. There is a lack of ambition for the judges to learn. There is a lack of ambition to acquire knowledge and to prepare themselves to where candidates stay for the moment when they would have really to apply the bulk of arrangements deriving from European Union law, including in the area of civil justice. Well, these figures are really telling about where we stand. They're really telling that there is a problem, there's really to work not only on the increasement of the advancement in terms of improving the professional skills of the judges, but also the mental mindset at the moment. Well, for the Republic of Macedonia, there are some explanation why this mindset is as such. I explain just briefly. Here, well, we are a little bit further from the accession to the European Union. We are now in a stalemate. Our process is stalled, like the Croatian one, because of the well-known difference over the name, peculiarity, that difference with Greece. But anyway, so people, judges also feel that the prospect of entering the European Union is quite remote, especially as has been expressed in the last 6 years. But that's not all. That is not the real explanation, in my view. There is a problem, especially there is a problem with the non-attractiveness of the judicial profession in our country. At the sessions, this is my personal experience in my classes at the law school, when I ask a group of some 50 persons, only one, in the best case, only one hand would be raised from among the students, those who would like to become a judge in the future. And believe me, that one hand would not be the hand of the best student in my class. So there are real problems that have to be tackled. The road is long-lasting. It's a very long road. But listening to yesterday's discussion, I have the impression that Macedonia is not alone on that road. Same troubles appear even in existing member states. The south, the road in the south mostly. But that road has to be passed. We have to go to that road in order to really, at the end of the day, provide for an effective system that would provide for effective access to civil justice in the European Judicial Area. Thank you. Thank you.